Welcome to the Deep Dive. We're here to break down complex sources into the essential knowledge you actually need. Today, we're tackling a really fundamental piece of law, something that touches almost everyone at some point. The Rental Housing Act 50 of 1999. We're looking at the consolidated version, the one updated back in May 2008, which governs how tenants and landlords interact in South Africa.
Yeah, this is such a critical area, and our goal today is pretty straightforward to unpack this act. It can look a bit intimidating if you just read the legal text cold. So we want to lay out its purpose, shine a light on those key rules that really matter when disagreements pop up, and explain how the whole conflict resolution system works, basically for anyone renting or letting out property.
Right, whether you're just curious about your rights or maybe even studying law. And what struck me immediately is that this act isn't just like a list of rules. It stems from something much bigger, constitutionally speaking.
Absolutely. That's the foundation. The Act flows directly from Section 26 of the Constitution. The right everyone have to access adequate housing. The government actually has a constitutional duty to make sure this right is progressively realized. This Act is, well, one of the main ways they try to do that.
Okay, so it's about more than just making sure rent gets paid on time. The preamble itself spells out a specific balancing act, doesn't it?
It does, quite explicitly. The aim is twofold. First, like you said, balance the rights of tenants and landlords. The idea is to prevent either side from just steamrolling the other. And second, it's about setting up these mechanisms, the rental housing tribunals, specifically to sort out conflicts speedily and crucially at minimum cost. It's also worth noting, for context, that this act replaced the old Rent Control Act from '76, which was much more, shall we say, rigid. This newer approach is meant to be about efficient fairness.
Okay, let's dig into that government role then, because Chapter 2 suggests it's not just about refereeing disputes. What's the government actually supposed to do for the rental market?
Well, their mandate is pretty broad, actually quite proactive. The government is required to promote a stable and, importantly, a growing rental housing market. The Act specifically says this is to meet demand, particularly focusing on helping people who are historically disadvantaged by unfair discrimination and also low-income individuals.
So it sounds like they view the rental sector as a tool, almost, for social and economic policy, not just a place people live.
That's a fair reading. The Act talks about introducing incentives, ways to encourage investment in rental properties, and working with the private sector to get more housing built. There's even a specific mention of the minister needing to set up a rental subsidy program for lower-income people, aiming to boost supply and correct some of those distorted historical settlement patterns.
Interesting. Okay, before we jump into the rights and wrongs, we need the basics, the definitions in Chapter 1. Let's start with dwelling, because that seems to cover more than just your apartment, right?
It really does. It's defined very broadly. Of course, it includes the obvious things, a house, a flat, a room in a hostel, even a shack. But here's the key part. If it's part of your lease agreement, it also includes things like a storeroom, an outbuilding, a garage, or even a specifically marked parking space.
Ah, okay, that's important. So if my lease says parking bay number 5, any fight over that bay falls under this act.
Exactly. It's part of the dwelling you've leased. As for landlords, that's the owner or their agent or basically anyone legally allowed to lease the place out. And a lease is just that agreement for the dwelling for housing.
Got it. And the term that keeps coming up when we talk about disputes, unfair practice, how is that actually defined? It sounds quite general.
It is intentionally broad. An unfair practice is basically any action or even a failure to act by either the landlord or the tenant that goes against the act itself. Or it could be any practice that's formally prescribed elsewhere which unreasonably prejudices the rights or interests of the other party. That wide scope is what gives the tribunal its power to step in on so many different issues.
Right, okay. Now for the really practical stuff in Chapter 3, the rules for everyday interactions. Let's start with how tenants are protected, particularly around discrimination and privacy.
Tenants get strong protections here. Landlords are explicitly forbidden from unfairly discriminating against potential tenants or their families or visitors. This covers grounds like race, gender, disability, sexual orientation, and so on. And crucially, tenants have a right to privacy in their home.
So what about inspections? Can the landlord just pop around whenever they feel like it since they own the place?
No, absolutely not. The Act is clear. While a landlord does have a right to inspect the property, they can only do it in a reasonable manner and only after reasonable notice. You're protected from having your home, your stuff, even your communications searched arbitrarily. And your possessions can't just be seized.
Wait, so even if I'm behind on rent, the landlord can't just say, change the locks and hold my furniture until I pay up?
That's precisely what they can't do. Seizing possessions can only happen legally through a proper process, usually involving a ruling from the tribunal or an order from a court. It prevents that kind of self-help situation.
That's a huge protection. Okay, flip side. What rights does the Act give the landlord? They need security, too.
Of course, landlords have the clear right to get paid rent promptly and regularly. That's fundamental. They also have the right to recover unpaid rent or other costs, and the right to get the property back in decent condition, allowing for normal wear and tear. But notice the pattern here. For recovering money or repossessing the property, they generally need to go through the tribunal or get a court order first.
So the theme seems to be no taking matters into your own hands. It always requires that official third-party intervention.
That's the essence of it. The power to enforce rights isn't with the individual landlord or tenant. It rests with the formal legal structures, the courts or the tribunal.
Okay, let's talk about the lease agreement itself. Does it have to be in writing?
Legally, no. An oral lease can be perfectly valid. However, and this is important, if the tenant asks for the lease to be put in writing, the landlord must do it. This gives the tenant the power to insist on having clear, documented terms.
Good to know. Now, the deposit. This is always a flashpoint, isn't it? The Act seems super specific about how that money has to be handled.
It is, and for good reason. These rules are non-negotiable. The landlord must invest the deposit in an interest-bearing account with a financial institution, like a bank. And the interest rate can't be lower than what you get on a basic savings account. Plus, the tenant has the right to ask for written proof of the interest earned at any point during the lease.
So the landlord can't just stick it in their current account or, worse, spend it.
Exactly. It ensures the money is safe and earns some return for the tenant, whose money it ultimately is until deductions are proven necessary.
And the Act insists on inspections at both ends of the lease.
Yes, very clearly. A joint inspection before the tenant moves in is mandatory. This is to list any existing defects so the tenant isn't blamed for them later. And then, just as critically, there must be another joint inspection within 3 days before the lease ends. This is to assess any new damage and figure out what, if anything, needs to be deducted from the deposit.
Okay, this feels like the real aha moment for renters, the deadlines for getting the deposit back.
Right. Pay attention here, because these timelines are legally binding. If there's no damage, no money owed, the landlord must refund the full deposit plus all the accrued interest within 7 days of the lease ending. 7 days. If there are deductions for repairs, say, or replacing lost keys, the landlord gets a bit longer. They have 14 days after the place is fixed up and handed back. But, and this is key, they must provide receipts for the costs they deducted.
14 days with proof. Got it. Now, what happens if the landlord just doesn't bother showing up for that final inspection? Are there consequences?
Oh yes, big consequences. This is a powerful piece of leverage for the tenant. If the landlord fails to do that joint exit inspection, the law basically says it's treated as if the landlord agrees the property is in perfect condition. And in that case, they must refund the entire deposit, plus interest, no deductions allowed, within those 7 days. It really forces the landlord to participate in that final check.
Wow. Okay. That's a strong incentive. So we have these rules, but what happens when someone breaks them? An unfair practice occurs. That brings us to Chapter 4 and the Rental Housing Tribunal, the speedy, low-cost solution we mentioned.
Exactly. The tribunal is really the workhorse of this act. Each province has one, established by the provincial housing minister, the MEC. And its makeup is interesting. 3 to 5 members, led by a qualified chairperson, but also including people with practical know-how in property management, housing development, consumer issues. It's meant to be multi-skilled, not just purely legal minds.
And who can actually file a complaint there?
Pretty much anyone involved, a tenant, a landlord, even a whole group of tenants or landlords acting together, if they believe an unfair practice has happened. The process itself is designed to avoid escalation if possible. First, a quick look, a preliminary investigation. If there seems to be a real dispute, they move to mediation, try to find common ground. Only if mediation completely fails does it go to a full, formal hearing before the tribunal.
And I noticed there are protections built in while that complaint is being processed, right, to stop things getting worse.
Yes, that's crucial. Once a complaint is officially lodged, and for up to 3 months while it's being dealt with or until a ruling is made, the landlord is barred from evicting the tenant. At the same time, the tenant has to keep paying the rent they were paying, and the landlord still has to do necessary maintenance. It kind of freezes the situation while the dispute is resolved.
Okay, let's talk about the tribunal's powers. They seem quite extensive. They can rule on living conditions, maintenance, even rent levels.
They can. Their main job is to make rulings that are just and fair in the specific situation. This definitely includes ordering someone to fix things, stop overcrowding, or sort out maintenance issues. But yes, probably their most significant power is intervening in cases of exploitative rentals.
Exploitative rentals. That sounds like it could be, well, almost like setting the rent. How do they decide if a rent is exploitative? That seems subjective.
It requires judgment, certainly. The Act says they should consider things like the general economic conditions at the time, what's a realistic return on investment for the landlord, and what the local market looks like. They aren't setting general rent control, but in a specific case where they find the rent charged amounts to an unfair practice, they can rule on what the rent should be.
Okay. And how binding is a tribunal ruling? If they tell a landlord to fix the roof or a tenant to pay up, does it actually stick?
Oh, absolutely. A ruling from the tribunal has real legal weight. It's considered the same as an order from a magistrate's court, and it's enforced in the same way. They could even issue specific legal tools like spoliation orders forcing someone to give back property they unlawfully took, or interdicts, which stop someone from doing a specific harmful action.
But there's one major power they don't have, which seems quite deliberate.
Yes, and this is a fundamental distinction. The tribunal cannot hear applications for eviction orders. It has no jurisdiction there. If a landlord wants to actually evict a tenant, even the tribunal has ruled on other matters, they must go to a proper court of law, like the magistrate's court or the high court.
Right. So this deep dive into the Rental Housing Act has been really illuminating. We've seen the constitutional roots, the specific rules around deposits, especially that investment requirement, and the significant role of the tribunal as this accessible, hopefully faster, way to sort out disputes.
And it's crucial to remember the teeth behind it, the penalties in Chapter 5. Ignoring key parts of the Act, like the anti-discrimination rules, or failing to provide a written lease when asked, or perhaps most importantly, failing to comply with a tribunal ruling, these are actual offenses.
Yeah, and the Act gets very specific about certain actions being offenses, things that directly impact a tenant's ability to live in the property.
Exactly. Things like unlawfully locking a tenant out or cutting off essential services, water, or electricity are explicitly listed as offenses, and they carry serious potential penalties. A fine or even imprisonment for up to 2 years. It shows how seriously the law takes preventing landlords from resorting to illegal self-help evictions.
Okay, so to wrap up, maybe a final thought for our listeners to chew on.
Well, here's something interesting to consider. The Act gives this administrative body, the tribunal, really significant powers influencing rent, forcing repairs, issuing binding orders like a court. Yet it draws a very clear line, reserving the ultimate power of eviction only for the judiciary, for the courts. So the question is, what does this deliberate separation tell us about the state's priorities? Perhaps it suggests that while the day-to-day administrative side of renting can be handled more efficiently by specialists, the act of actually removing someone from their home, impacting that fundamental right to housing, is considered so serious it must remain strictly within the realm of the courts, demanding the highest level of judicial oversight. Something to think about.